She's an 18-year-old who literally kicked and beat a 14-year-old and then had the gall to post another video of it on TikTok. This is case number 251740SM.
On October 10th, 2025, 18-year-old Amanda Jones entered Michigan's 84th District Court expecting to resolve a misdemeanor assault case. The charge carried a maximum of 93 days in jail. Both attorneys had already agreed on a path that could erase the case from her record. Then Judge Jason Hartel read the police report. The alleged victim was 14. The incident had been recorded near Cadillac's Old Dam.
Number 251740SM. Appearances counsel?
Nick Carnes on behalf of the people.
Ms. Jones, you come over here. We are set for a pretrial conference. It appears we have a resolution in this matter, Mr. Carnes?
Yes, Your Honor. It's my understanding the defendant will be pleading no contest as charged. The people are supporting a delay of sentence with a full dismissal if the defendant is successful on the delay. Success on the delay would be whatever programming is recommended by probation and violations of typical probation admissions.
Was that a Killebrew?
Yes.
Okay.
And the reason for the no contest plea is potential civil liability, Your Honor.
And so just so we're clear, the success was completion of programming and no violations.
Correct, Your Honor.
Mr. Hassel?
That is accurate, Your Honor.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement, and what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence, and if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
Counsel, I've been provided with a Cadillac Police Department report, incident number 2500819. It's been marked as People's Exhibit number 1. Mr. Carnes, do you move for its submission?
Yes, Your Honor.
Mr. Hartel?
Yes, Your Honor.
No objection then. The People's Exhibit number 1 is received. Give me just a moment to review that. We are back on the record. I've had the opportunity to review the People's Exhibit number 1. Do counsel believe that it forms a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by the old, what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac and is between Haynes Street and River or Wright Street on the what's now known as something along the lines of the Green Trail or the Green Pathway. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned Round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise, although I question what the civil liability would be since there's no injuries. I trust you on that, but I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Olst because I had a conflict on that because I was the elected prosecutor when that was arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with
Jones entered court with both attorneys supporting a second chance. She left still facing sentencing because the judge refused to let that recommendation become automatic. For case depth, the lesson is simple. In a courtroom, a social media post is not merely content. It can become evidence of attitude, judgment, and intent. And two careless words can change what a judge is willing to accept.